Hello and welcome to WorldCanvass from International Programs at the University of Iowa. I'm Joan Kerr. We're coming to you from Film Scene in downtown Iowa City, and we're happy to have you join us for part 3 of this series on tobacco, pot, and the public interest. Our guests in this segment will help us explore the tension between personal freedom, much of it guaranteed in the U.S. Constitution, and the notion of the public good or public interest, which guides so much of our communal action. Regulatory issues and public attitudes toward tobacco and marijuana raise critically important questions for our society, questions about the concept of the public good. For example, where exactly does the perceived public good bump into constitutionally guaranteed rights of personal liberty? In regulating harmful products or substances for the public good, are we legislating morality? We hear these terms thrown around a lot, and our two guests here will help us sort through some of this. And I'm very happy to be able to introduce Todd Pettys, just next to me here, who teaches at the University of Iowa Law School and is also an associate dean. Thanks for being here, Todd.
Thanks for the invitation.
Real pleasure. And very nice also to have you, Doug Beardsley. You are the Director of Public Health here in Johnson County. And so thank you very much for rejoining us in this third segment of our program.
Thanks for inviting me.
Yes. For anybody who's interested in finding out a little bit more about this program, past programs, don't forget that you can find all that information at the International Programs website, international.uiowa.edu. I'm going to go to Todd first because I think we need to get a little bit of grounding in what our Constitution does and doesn't say about regulating personal behaviors, individual rights. Always a hot topic in this country, whether it's a political debate or whether it's neighbor to neighbor. And so I wonder if you can tell us, what does the Constitution say about personal interest when it comes up against public interest, or what we think of as the public good?
Well, for the vast majority of things, we're left to our own devices, so to speak. We're free to be our own heroes. We're free to be our own victims. There's nothing in the Constitution that has some kind of an intelligence meter or something, that only laws that are justified and so forth are valid. And so we can pass foolish laws, we can pass smart laws. There are, of course, some individual liberties that are spelled out in the Constitution. The right to speak, the right to practice religion, those get varying levels of protection. Most of them get quite a high level of protection. But what those rights largely serve to do, particularly with issues like tobacco and cannabis, is it sets the framework within which we're going to have these conversations and figure out what kinds of policies we want. And so we have the freedom of speech, for example, where we can debate what the policy should or should not be. We can lobby our legislators. We have rights to vote. There's an equality of voting, so my vote counts no more nor less than yours. And out of that comes some sense of policy. There's another sense in which the Constitution sets the framework, which is through our federal system of government. We have 50 states, and to the extent we wish to use them in this way, as the famous saying goes about states being laboratories of experiment, we can try different things in different states and find out, if we increase access to cannabis, for example, for certain purposes, what are the long-term consequences? If a state raises its hand and says that it wishes to proceed down that road, it can do so to the extent federal law doesn't interfere. And so with things like tobacco and cannabis, matters about which the Constitution is silent, we're left free, at least at the constitutional level, to do what we want to do, whether that's turns out to be in our health interest, or it turns out to be quite regrettable.
Mm-hmm. And so we'll be talking to Director of Public Health in a moment here, but from your point of view, when did this idea of sort of the public good sort of we speak in our most treasured U.S. documents about having the right to become whatever it is we ought to be, pursue our own happiness and so on. But there is also common defense and a sense of community within the United States, right? Is there any place within the constitutional documents or any of our founding documents that says that we need to look after our neighbor's health? Or where does this, where do we find language about that we very often hear in national political debates, that my freedom stops at your door, or, when did that all get written into the way we think here in this country?
Well, that's hard to answer. You can't identify a particular document or name a particular date. It's kind of an ethic that pervades our constitutional tradition. Our Constitution, when it comes to individual rights, speaks much more about what the government cannot do to us than it does about what the government is obliged to do for us. That's a kind of a big watershed distinction that shows up quite a bit. So, when we think about what is in the public good, the Constitution identifies some things that have been deemed to be in the public good. It's deemed to be in the public good if we have a right to speak. It's deemed to be in the public good under the Second Amendment if there's some right of access to guns, about which we could have comparable debates about public health consequences and so forth. And with respect to the rest of it, we're free to define the public good for ourselves. Now, the Supreme Court has told us a little bit in the relatively recent past about what kinds of justifications are sufficient to define the public good. And so, for example, with respect to same-sex sodomy, in a case called Lawrence versus Texas, the court said that, well, Texas had said that if members of the same sex should not have certain kinds of sexual relations with one another. And Texas then tried to defend that law, saying, in our judgment, it is in the public good to have this prohibition. And the Supreme Court told us in that case, by a narrow vote, 5-4, with a quite vocal dissent on this point, that mere moral disapproval is not enough. So at least when it comes to certain sexual intimacy practices, merely the majoritarian judgment that this is immoral behavior is not a sufficient justification for making it illegal. Whether morality is a sufficient justification in other settings, somewhat ratcheted down from the privacy instinct that we often have about sexual intimacy, remains an open question. And if morality is not sufficient, then it typically is some kind of adverse impact where the surrounding majority can say it's not just because we think it's wrong, but because we can identify X, Y, or Z consequences that's going to flow to the rest of us if you are allowed to do it. So pornography, for example, or obscenity, which is the constitutional term of art. Obscenity is a form of speech that gets no constitutional protection, and it was deemed not to have constitutional protection because, for a variety of reasons. One is, the court said, a community is entitled to decide that having theaters where even just consulting adults go in and see certain kinds of material, that when they come back out of the theater, they're going to have some kind of an impact on the larger community. And so we're going to leave communities free to decide whether they want that influence in their community or whether they don't.
Yeah, well, so let me throw it down to you, Doug, and talk a little bit about how health-related initiatives bubble up from the public. If there is a desire within the public, groups many years ago saying, look, I don't want people smoking next to me at the restaurant that I'm eating dinner at, or I'm in a classroom environment and I don't want to have all this smoke around me. If we could think of any of the arguments that one heard, in my case, when I was in college years and years ago, there were people who were trying to, stop other students from smoking because they didn't want it in the air they were breathing. So sometimes and I remember thinking at the time, oh yeah, that'd be nice if people would stop smoking in this classroom because I'd rather not have it too. But I never thought that all these years later we'd be in an environment where now we have communities legislating certain sorts of environments where you can't do things that affect other people, like smoking. So how does this happen when it comes from individuals?
Well, I mean, you've mentioned it. You both have touched on that. It's when someone's actions is going to affect, and in public health, the health of someone else. And it was mentioned in a previous segment as the science became better. So let's go back to the tobacco. You smoking, we knew it did harm to you. In 1964, the Surgeon General brought together research. What should we do about that? And there were certain things, one, education, let's warn people this is not good for them. But then we had the science that your smoking affects me, affects my health, and we could begin to quantify the morbidity and mortality, the disease and death to the innocent bystander, if you will. So then we started getting laws to protect those folks. one of the good benefits of that was then the smokers were inconvenienced and perhaps nudged towards reducing their use or deciding to quit. We see this a lot with some of the regulations that we have for vaccinations in schools. In order to register in the public schools, or even a lot of the licensed private schools they've adopted, your child needs to be vaccinated. Not necessarily, again, in terms of public health, from my point of view, not necessarily, I don't want to vaccinate you to protect you. I do. But really, it's to protect I'm protecting the larger public, or the public at large. So, we're looking at ways, are we reducing harm? We mentioned, morality. Well, is it moral? We are, in essence, legislating morality by the definition of, is it moral for your actions to harm me? A lot of what public health does is we look at data, we assess what's going on in a community, and then digging down to what are the factors then that pose harm to us, and then we propose regulations to the policymakers, say this needs to be regulated because it's doing harm here.
What kinds of public health challenges do you face? You direct public health here in Johnson County. What are the biggest challenges you think right now that need to be addressed by our community?
Well, I've talked about health assessments, and I can tell you the health assessment, heart disease, cancer, strokes, et cetera, and I can link it back to tobacco. Tobacco, to me, is still, it's still quantifiably the #1 cause of premature death and disability in the United States. There's a lot of things we could do. I don't know if, do we, some of the criticism is, well, if it's that bad, why don't you propose just to outlaw it, do away with it? Now we're starting to step on the toes, do I have a right to tell you not to kill yourself, or do things detrimental to your health as long as it's not affecting me? I don't think we're in a political situation, and there's all sorts of arguments that we're ready to take that on. So we're trying to, again, do things to protect those who are too young to make that decision. We do that all the time. There's a certain age where you can get a driver's license. There's a certain age where you can buy tobacco, consume alcohol, do other dangerous or potentially dangerous things. So that is regulated, and we want to see those tightened up. There's a number of issues of access to tobacco, also e-cigarettes, which is, there's some knowns, there's still some unknowns, so we want to be precautionary and say, what can we do to get out ahead of this? Do we need to, in 20 years, go, darn, I wished we'd gotten ahead of it, because now we see that there's really bad results here. So we have the opportunity, let's be more precautionary, regulate them, use some of the same strategies we have with tobacco. But there's resistance, because not all of the data, we don't have all of the data yet because it's so new. So keeping up with data that makes sense is always a challenge. And just because the data is there and the data is good doesn't mean it's accepted. Some people don't want to be confused by the facts. And policy is difficult. And our Constitution allows us to make good decisions or bad decisions. So it's always a challenge, how far do we want to go? Do I want legislation on the size of sodas you can drink? Me personally, I'm not ready for that, because you drinking a large soda doesn't affect my health. However, if you develop adult onset diabetes, or you die prematurely, that does affect society. So I do have an interest in your personal health.
And it's worth underscoring, those are questions of political rights, not really questions of constitutional rights. Whether they're talking about large sodas or tobacco or cannabis, the question is, politically, do we want to acknowledge a right of access? It's not a constitutional question, because the Constitution does have this concept of liberty, kind of an amorphous, almost all-encompassing notion. Unenumerated rights would fall under that tent. but with limited exceptions, the right to privacy, in which the abortion right is based, being a notable exception. For the most part, the court would say, yes, you do have a constitutional right to smoke in a sense, okay? But it gets very minimal protection, and in order to invade that right, the government only needs to have a rational justification, okay? And in the language of constitutional law, demanding rationality is a very low threshold. It's not a requirement that by a preponderance of the evidence you can show that it's harmful and so forth. It's a very, very low threshold where the courts are leaving policy-making bodies, state legislatures and Congress, free to do what they wish. So yes, there's a sense in which you have a constitutional right to drink or to smoke or to have large beverages, but the government's free to take those things away so long as it has a rational justification. That's our understanding up to this point. So it leaves these things almost entirely in the political realm, so it becomes a question for our elected leaders and for voters on election day to decide whether they're happy with the course of policy making up to that point.
If you look back over the last century or even longer, has there been an increase in the sense of, I'll turn to you for this one, Doug, I suppose, because public power in terms of helping to push health agendas forward, would you say that we can look back over history and say this really ramped up at such and so era, or this particular crisis caused the public to realize that they had to step up and push for kind of communal change?
Well, I don't know if I'm the best expert on the history of that. Some of the things, in my recent history, we look at things like, an outbreak, H1N1 was, anytime there's a crisis, there seems to be more willingness of the public to say, we need to do some intervention here. Allow the government to spend some money to do some things, maybe will be a little less critical of efforts to quarantine or isolate. When things are going well, why do we want to ramp it up again? So, I mean, that's a hard. I wish I had a better answer for you, but things go. There are certain landmarks. I mentioned, the Surgeon General report in 1964 was a huge landmark. It got people's attention. It was a position of stature which was a great educational tool and woke some people up, or it empowered some people to say, hey, that tobacco smoke has always bothered me. It stinks, my clothes stink. I want to do something about this. And you didn't see immediate changes, but though I think some landmark things like that were the start of changes.
There's an interesting, one of the big cases in American constitutional law concerns this this question about early efforts to try to intervene on behalf of public policy. And it involved New York lawmakers deciding that bakers faced particularly dangerous working conditions. They were inhaling flour dust all the time. They were on their feet. They had to get up very early in the morning. It was hot. They worked terribly long hours. And so lawmakers decided that they were going to put a limit on how long someone could work as a baker, how many hours per day, how many days per week. And it was grounded in public health concern, or at least the health of those in the baking profession. And it went up to the Supreme Court, and the Supreme Court famously within constitutional circles struck down the law, deeming it insufficiently justified, and recognized something that was called the right to contract. If a baker wants to work 18, 20 hours a day and someone wants to pay him to do it, they've got a right to do that. And these not very well substantiated, the court said, health concerns for the baker, they're just not powerful enough to justify interfering with this unwritten constitutional right to contract. It's called the Lochner era in the early 1900s, when the court got very aggressively involved in looking at either public health or quasi-public health efforts. The state of Oregon decided that women, particularly pregnant women, shouldn't be on their feet for long periods of time in factories. And the courts got just engaged in the project of deciding whether the health justifications for these laws were sufficient to warrant them. And the story is that by the late New Deal period, the court beat an almost total retreat and said, you know, for us to be involved in closely scrutinizing these laws to see whether they're sufficiently justified, we're not institutionally competent to do that. This ought to be left to elected officials, which really opens the door to those in the public health profession or who want to lobby those in the public health profession or however the system works to decide for themselves on the strength of evidence or not on the strength of evidence what kind of policy they're going to have. But that has been a century now since the court experimented with being involved heavily in this area and decided this really isn't for us.
Well, I had that entirely wrong. I would have thought that the New Deal era was a time when the courts were really trying to sort of be out there working on behalf of what we conceive of as the public or the public interest. But it's interesting to hear you say that really the...
It would depend on how you define what the public
Yeah.
interest is. I mean,
Yeah,
you've
yeah.
got to talk about early New Deal and middle and late
Yeah.
New Deal. The court was very involved, you know, about rights to unionize and being one of them, working conditions and so forth. And in the early New Deal, the court was itself taking a close second look at the rationales underlying these various legislative enactments. By the end of the New Deal and kind of in constitutional law, we kind of mark the end of the New Deal with the court saying, we're just going to scrutinize these laws for mere rationality. And we know we go decades and decades and decades before we see the court again even venturing in any kind of tangential way to get back involved in that project. And if you list the top 10 worst Supreme Court decisions of all time, those who study constitutional law would pick one or more from that era saying it was really inappropriate for these unelected, largely politically unaccountable justices to make these decisions for the public. People ought to be able to get the kinds of policies that they want, and to a large degree, the court has held true to that lesson.
I see.
And I think that's kind of the point I was trying to make earlier is, you know, we can provide information, education, whatever data, but it's still going to be an opinion. It really does come down to a political opinion or public opinion, as by who you vote in. Was this important enough? Did we make our case? You know, did the opposition make their case better? You know, and I remember having a staff meeting, and we had one of our legislators in there, and one of the staff asked, why can't they just do the right thing? Well, the right thing is a matter of opinion. You know, I think it's the right thing to protect someone from harmful tobacco smoke. Someone else may not think that is right. So it's our job to influence, educate, nudge, encourage things that we think are for the public good, in my opinion, or who's ever my collective opinion, not me. I'm not the boss yet. Only of a small group. You know, so that really, you know, kind of going back to your question, that's really the challenge is, you know, finding that balance. I can make a recommendation, you know, I may disagree. You know, I say, this limiting soda size, I may convince myself that that's the best thing to do to prevent diabetes or obesity. You know, I might be wrong, but then it's my job to try to convince someone of that, take action. If they don't take action, that then was the political decision, and I need to continue to do things that I think will improve the health or the environment for health.
Take something like tobacco. You know, let's take the case as settled that tobacco is harmful. Even there, defining the public interest, there's room for ideological disagreement. You know, you can say we can define public health on the one hand, saying it's a harmful product. You could also say, well, it would be harmful to the public to let the government regulate, because then the people become dependent on the government to make decisions for them. And you hear that. You even heard it's been some time since people made this argument in mainstream politics, but people ought to be able to play out the course of their own decisions. If they want to do something as foolish as smoke tobacco and die an early death, then let them do that, and it's better to weed those genes out of the gene pool now. You can find historical proponents. You can find historical proponents for those views, and all of them think they're making arguments based on the public interest.
Yeah.
You know, and one last I'll try to squeeze in
Oh,
here.
no problem.
You know, we talk about you know, allowing personal freedoms. I think one part that we haven't discussed and that we really haven't grasped then is then you need to take full ownership of your actions. So the person dying of lung cancer or heart disease, what's the public's obligation then to treat, to care for them or their family? And I think we've removed ourselves from responsibility of action.
Get fuzzy, though, in an area like tobacco, because if I have lung cancer, it's not because I ever for one moment smoked a cigarette, but I grew up in a household where people did smoke. So, you know, am I the actor in that whole bad decision? Probably
Well,
not.
Yeah, and then we can have the whole debate about do we as a moral society have an obligation to care for those who can't care, regardless of how
Yeah.
they got in that situation and not
Yeah.
be judgmental. So maybe the next program we can
Yeah.
continue on that.
Yeah. Did you have any last thoughts? Okay. Well,
I'm
boy,
going to leave
this,
it to your clock.
no, this has been really great. So Todd Pettys from the University of Iowa Law School, thank you so much. And
Thank you.
Doug Beardsley from Johnson County Public Health, thank you. It's
Thank
been a really interesting evening for all of us, I think, so thanks. And I want to thank all of you for coming to our live show and everyone for watching. That's all the time we have right now, but we have another program coming up on March 3rd, and this program will be here in this same place, and it's about energy cultures in the age of the Anthropocene. If you haven't heard this term yet, you'll be hearing it probably in the future, and you can hear about it on March 3rd. We will be here in this room once again, and if you'd like to watch this show or any of our other WorldCanvass programs, you can find them on UITV, on YouTube, and on iTunes and the International Programs website. So thanks very much for being with us for tonight's program, and we hope to see you all on March 3rd. Thanks so much. Thank you.